Hi, my name is Ejaz Heather, and I welcome our viewers to another Justice Project Pakistan episode on police reforms, criminal justice system, and allied concerns with reference to police excesses, torture, and rights violations. For those who might be joining us for the first time, this is a series of sessions or podcasts, if you will, which we have been doing as part of JPP's efforts to put these issues on the map and press for reforms in general and legislative reforms, including, and that's very important, the criminalization of torture. Many countries, including Pakistan, have signed the United Nations Convention Against Torture and the International Covenant on Civil and Political Rights. Most have brought domestic legislation in line with these conventions, either fully or partially. Even so, in many cases, there's little enforcement or even normative acceptance of the basic values these conventions identify and uphold. For various reasons, not least for political and authoritarian reasons, many countries continue to ignore the values enshrined in these conventions. In many other cases, it is also a problem of individuals who might believe that torture is a quick way to extract confessions. So it's essential that activists, NGOs, and civil society members continue to seek remedies against such practices. This session, like the previous one, is being conducted in English because our expert today does not speak Urdu. I'm thankful to Professor Mark Berlin, who's joining me today for this discussion. By way of introduction, Mark Berlin is an assistant professor of political science at Marquette University in Milwaukee, Wisconsin. He teaches courses on international law, international organizations, and human rights. His research examines politics at the intersections of international law, domestic law, and human rights, with a particular focus on domestic and international accountability for violations of human rights and the laws of war. His book, Criminalizing Atrocity: The Global Spread of Criminal Laws Against International Crimes, was published in 2020 by Oxford University Press. And let me also, for our viewers, if you want to stay in touch with Professor Berlin's work, since Twitter has become big, he tweets at Mark underscore Berlin. So without much ado, let's dive right into this discussion. So, Mark, I was reading a paper that you wrote for the American Journal of Political Science titled Does Criminalizing Torture Deter Police Torture? And you have some very interesting observations in that paper. Uh, and you stress that there is a reason why it's important to criminalize torture. So I want you to start from there. There are other points also in the paper, and I would like to problematize some of what you're saying. But let's first begin with an overall sort of overview of the paper itself.
Absolutely. Well, first of all, thank you for having me. It's my pleasure to be invited onto this broadcast and to discuss these important issues with you and your organization that does terrific work on these issues. So yes, the UN Convention Against Torture, which you mentioned, requires states to domestically criminalize torture so they can prosecute it in their own national criminal justice systems. Now, there's a number of reasons why adopting a criminal law against torture is important for trying to combat torture. Most simply and straightforwardly, having a law on the books that criminalizes an offense called torture and defines it specifically as the definition in the UN Convention Against Torture does. Having such legislation is important simply just for being able to prosecute the crime. In other words, having a crime of torture makes it easier to prosecute than as opposed trying to prosecute acts of torture through alternative criminal offenses, say like laws that criminalize assault or something called forced confessions. And there's a number of reasons why that is. First of all, the definition of torture in the Convention Against Torture is fairly specific, and in doing so covers a full range of potential scenarios and modes in which torture may be used. If you are trying to prosecute cases of say, police torture using other offenses in the criminal code, say assault or other offenses committed by police in the criminal code. Oftentimes, those offenses are perhaps not defined at all, and if they are defined, like what conduct counts as that offense, it often does not include a lot of actions that may still constitute torture. For example, at least in the United States, the laws we have on things like assault, usually cover physical violence. But torture is, certainly may be physical, but in many cases, police may use methods that would be considered psychological or mental torture, sleep deprivation, humiliation, threats to family members, threats to execute a prisoner. Those types of actions count as torture under the Convention Against Torture. But if you don't have laws that specifically designate or identify those types of acts as torture, then it's much harder to prosecute them. So just having a basis in law that covers the full range of actions that could count as torture is important for being able to prosecute torture in the first place. And that's important because if you get in the mind of a police officer, for example, they're much less likely to go ahead and commit torture if they believe there's a higher likelihood that they could be held accountable, if they could be punished or prosecuted for torture. And having laws on the books that make it easier to prosecute torture helps increase the perceived threat of punishment or accountability for using torture. So in that most straightforward way, criminalizing torture helps send a message to would-be perpetrators that their conduct could be, seen as a violation of the law and could be prosecuted. But beyond that kind of very simple relationship between the law and behavior, criminalizing an offense like torture contributes more broadly to, say, preventing torture by, for example, adopting a criminal offense against torture can help change the mindset of a number of different types of actors whose actions matter for accountability. So, for example, many police officers might not even consider that certain types of actions that they typically take when interrogating suspects would even count as torture in the first place. So especially in places where, physical pressure or physical coercion on criminal suspects is considered normal or routine or accepted, depriving somebody of food, depriving somebody of sleep, putting somebody in a stress position, maybe using physical violence and beating somebody. Maybe police officers don't even consider those forms of action as torture. And defining torture in criminal law helps clarify for those kinds of people, what torture is. Certainly, that's not going to eliminate torture. That's not going to persuade all would-be torturers not to use torture. But for those who may not have thought about their actions very much, it can lead them to call into question their own kind of the moral status of these actions that they had typically thought of as not very problematic. Likewise, it can empower civil society actors, advocates, NGOs, like your organization, to be able to better raise awareness among potential victims of torture, to help them see that the abuse that they experienced was not just something that they should accept, that's just some routine, normal part of the criminal justice system, but is actually considered a major violation of international law. And perhaps that gives them more motivation to want to bring complaints to judges or the police, or helps NGOs kind of raise awareness about what kinds of conduct count as torture. So I could go on, but there's a number but that kind of covers a number of reasons why recognizing and defining an offense of torture can contribute to reducing torture in the long term by both changing the cost benefit calculations of those who are in a position of torture, as well as helping to galvanize action on behalf of those who may be able to hold police accountable.
Right. So let me just try and quickly summarize, or get a sort of essence of what you've said. So, one, the need to have specific legislation will obviously, in terms of the defense of a police officer, where there are other issues like assault and the rest of it, where there are other technicalities involved in terms of, the difficulty to pin an officer down. So that will be taken care of. Secondly, once you have the specific legislation, then of course you are defining it specifically and broadly what exactly constitutes torture. And so therefore, the police officers cannot say that they do not know that sleep deprivation or psychological pressure or pressure on friends or relatives and the rest of it, there can be a number of tactics that the police can use that they did not know, or they were not aware of the fact that these issues can be taken cognizance of under this law. And thirdly, that would, over a period of time, also begin to A, in terms of prosecution, and B, in terms of also of a broader normative acceptance of the fact that these are practices that cannot be, that are not acceptable. Have I got that right?
Exactly. Yeah. So, I mean, just to cite another example, I noticed in the data that you folks have collected on torture in a couple of different districts, I believe in the Punjab
Yes,
state,
in Faisalabad, yeah.
right in Faisalabad, yeah, and
Yeah.
that if you look at the methods of torture that have been reported by the victims, overwhelmingly it's physical violence, physical beatings, and a very small portion of those are, say, like sleep deprivation or food deprivation. And that that may reflect the actual patterns of behavior, but that also may reflect the fact that victims themselves may not perceive deprivation of food or deprivation of sleep as torture. They don't perceive their experience as being tortured when they experience that kind of abuse. So there may be not likely in those cases to bring complaints because they don't see their own situation as violating the law. So that's another way to see that the data that you've collected as reflecting a lack of awareness on behalf of victims that that kind of conduct would be abusive or illegal.
Absolutely. I think that's a fantastic point. But Mark, before I go back to the data set that you talk about in your paper, uh, a segue of sorts, but sort of links up with the idea of actually doing this, resorting to torture, whether physical or psychological slash emotional, to extract confessions. Now, when the war on terror began, uh, the CIA was given authority for what was euphemistically referred to as enhanced interrogation techniques. But apparently, studies subsequently have shown that they were not really very effective.
Right.
And so I'm assuming, going by that experience, that confessions thus extracted would also be problematic for the prosecution itself. I mean, because this is like a ladder, and the police is the first rung of the ladder. You have to go further up the ladder through the criminal justice system in order to actually sift the grain from the chaff and to prosecute the right people, not the wrong people. And mostly, when you're extracting confessions like this, you might actually, in lots of cases, end up prosecuting and sentencing the wrong people rather than the right people.
Yeah.
So, is that something that you think is important to flag in terms of pushing for this kind of legislation?
Absolutely, yeah. So you're right to point out that. So, for example, the U.S. Senate, a committee in the U.S. Senate here, investigated the CIA's torture program and concluded from that investigation that um, that the U.S. torture program produced almost no, if any, usable, accurate intelligence that wasn't already or couldn't have already been gained through other means. So, you know, there's been a lot of research on this, and generally it's believed that torture is not effective for gaining the truth. Torture is not very effective for gaining intelligence or getting somebody to tell you the truth. But what torture is effective for is getting them to tell you what you want them to tell you.
Yeah.
So if you are concerned with prosecuting the correct person, then torture is not very effective. In Chicago, which is right down the street from where I live, there is a couple decade long scandal of widespread torture in the Chicago Police Department by Chicago police detectives, and the aftermath of that scandal is still being felt. And by that I mean that even today, decades after supposedly that scandal was over, there are still people in prison who are being released or exonerated as more information comes out and as their cases are being challenged. So here we have cases of people who were prosecuted based on false confessions that were tortured out of them, and now the city of Chicago is paying the price by having to release people and have those crimes be unsolved now.
Which is which. Yeah, sorry. I just thought, I'd flag this point, which is also a very important feature as far as the campaign against death penalty is concerned. Because here we are talking about people sentenced to long prison terms, but they're still alive. So, as and when information comes in, you are able to exonerate them, and they can come back to. I mean, of course, they've lost many years of their lives, but at least they're still alive. Imagine cases in which people have been sentenced to death, and the sentence has been executed.
Right.
There is no way, because there is a finality about that which cannot be reversed. So I believe that that's also a very important point in relation to what you're saying.
Exactly. Yeah. And I mean, in the state of Illinois, where Chicago is, that very issue led to the end of the death penalty in Illinois, because there was so much revelations about the false confessions and false convictions, and a subset of those people were put on death row and sentenced to death. A small number of those, I can't remember off the top of my head, but perhaps maybe about 6 or 10 people who were sentenced to death has since been exonerated and released. And that concern over widespread false confessions and false convictions of people sentenced to death led to Illinois to end the death penalty here. But I just want to end with one point related to what you were saying before. Yes, torture is not good for finding out the truth about who may be guilty or not guilty, but that assumes that those who are doing the interrogations care. So in the case of Chicago, in many cases the detectives didn't really care whether the person that they were interrogating was guilty or not. What they were concerned with was just closing the case and being able to say that they solved the crime. So that's an important part of the equation as well. Some police, do genuinely care and want to find the right person. But if you have detectives or investigators who don't really care, that's not necessarily a good argument for persuading them that torture is not useful.
Right. Now, as I said, let's just problematize this. Let me pull up your paper. Okay, here it is. Now, you say that the nature of delegation from governments to frontline agents means that agents may defy leaders' preferences against torture. if they believe it is useful for their goals, such as obtaining confessions, and they expect to face little cost from doing so. Now, we have just discussed the case of the CIA enhanced interrogation techniques. Now, in that particular case, as also in many other cases across the world, while the frontline agents can also individually do certain things, sometimes in certain cases where states are fighting insurgencies or so-called insurgencies, or where they're fighting people who want freedom, like in the Indian occupied Kashmir and elsewhere, there is this kind of policy actually, and there are actually laws which are black laws, which allow uh, so much leeway uh, without any accountability of the security forces, whether it's the military, the paramilitaries, the police, that it's not just the individuals. It, in fact, gives a fillip to an individual's sense of sadism, perhaps, if you will, that there is a state policy behind this. Now, when you have something like that, then the issue becomes even more problematic. Would you
Yeah.
agree with me?
Absolutely, absolutely. There's a big difference between torture committed as a result of a policy or direction on behalf of political leaders versus torture committed by, say, police officers or security agents on their own initiative because they believe it's useful for their immediate purposes. And so the logic is very different in that when torture is authorized by the high levels of governments or policies, it's much harder to combat it. It's much more harder to end that form of torture because you need those higher authorities to be willing to exercise their power, exercise their authority to hold perpetrators accountable. And if those higher authorities are implicated in those abuses, then the avenues for accountability are much more limited.
Right. Now, I'm also going to touch upon the Black Lives Movement issue and racial discrimination. But before that, I want to get your view on something that we have witnessed from afar, but there are lots of studies within the US about this, which is about the militarization of policing. And in the last 20 years or so, there has also been an increase. Correct me if I'm wrong, but I've seen some stats on this, of the former special forces personnel being inducted in police departments across the US. Now, these guys are highly trained operatives. They were trained to operate in combat environment, and urban and peri-urban policing is very different, I would think, from that. But given the kinds of weapons they carry and given the mindset that they bring to policing, do you think it is a problem? Is it something that experts in the US are looking at?
Yeah, absolutely. So this is a little bit further outside my area of expertise. I'm not an expert on policing generally as much as I am on kind of custodial abuse and abuse of
Yeah.
prisoners in custody. But so I can't comment on the statistics per se about how many members of the military or go into policing and whether that's increasing or not. But there certainly has been an increase in kind of military style approaches and tactics, as well as weapons being used by U.S. police forces. And I think that certainly is a problem. I mean, first of all, it's certainly just as in terms of appearance, creates a problem in terms of how the community sees itself in relation to the police. If it sees, because that sends a message when the police become more militarized and use more military style weapons, that sends a message that the civilian population is somehow kind of the enemy, and that establishes a kind of adversarial posture towards the police kind of right off the bat. But it also kind of contributes to a certain kind of attitude on behalf of the police to see their job as being more about kind of domination and control. I mean, this is already part of how police officers generally are trained in the United States. For the most part, they're trained to see situations through the lens of threats and through the lens of control, and they're trained to see the control over the situation as the highest priority, and that contributes to conflicts and violence by putting police in a situation where exercising control over a particular scenario may actually escalate the situation in such a way that leads the police to use force than maybe more likely than they maybe would have otherwise if they didn't feel the need to exercise control. So, for example, one of the there's been a lot of interest among activists and commentators in the United States in trying to offload some of the types of tasks police are called upon to do that they don't necessarily need to be called upon to do, but that just by default they are called upon to do because there is no other system in place. So, for example, police are often called to respond to mental health crises. Someone on the street having a mental health episode or acting out, and police may be called, and because they are trained to kind of exercise control over a situation, trying to exercise control over that individual might cause that individual to lash out, which then escalates the situation further and leads the police to use force. So instead, there's kind of proposals to establish mechanisms whereby instead of police responding to situations like that, unarmed social workers respond to situations like that. So I think that relates to your question about militarization, because I think militarization just further exacerbates those issues, just further contributes to a sense of us versus them and kind of need to exercise domination in situations where exercising domination might actually produce the opposite result of actually making things worse.
Absolutely. Now, so given the idea of preemption through broken window policing, we have seen that a lot of such patrolling and preemption takes place in Hispanic or Black neighborhoods. And that kind of also links up with how the police forces in the US approach these ethnic groups. I don't have to spell it out. There's so much has been written about racial discrimination, and of course, a lot of literature has also been put out by the Black Lives Matter movement. Is this also a big problem? And I ask this because, as you know, Mark, in the post-Reconstruction period, for almost 100 years, this was with the Jim Crow laws. This was a major problem. People were lynched, they were burnt alive. There were times when the police forces could not do anything because the mobs wanted to do something. And it was after a long period of arduous struggle that things came to an even keel. But it seems that just below the surface, at some subterranean level, there is still that, and we see it, sort of recrudescing like a bad case of eczema, and that kind of adds to the problem of actually, if we go back to the benchmark of the discussion, which is criminalizing torture, which is also the subject of your book and the paper from where I was quoting.
Yeah, so you're absolutely correct. These issues of kind of discriminatory policing and kind of disproportionate distribution of policing in minority communities in the U.S. Is a major issue, and it seems to be related, in part at least, like you're suggesting, to the legacies of institutionalized discrimination and violence against those communities, that even though it has kind of ended in terms of the kind of official, legal, institutional grounds for those kinds of discrimination and violence, the legacies of it continue, And we see, the legacies in terms of kind of disproportionate levels of poverty, and poor health outcomes, and unemployment. And it just kind of feeds a cycle whereby, because these communities are so disadvantaged as a result of these historical trajectories, they're more likely to be places where there is more crime. And so then the police, folk target those areas more, which then contributes to more tension and escalation, which then leads to more policing. So it's this kind of, bad cycle that doesn't get interrupted. Related to also to what you said, I think one of the big contributors in the United States and in a place like Pakistan is the perception on behalf of police that there is very little cost or a threat for them to use violence or abuse or to break the law. You can have all of the laws on the books that you want, and you need laws on the books in many cases to be able to reduce police violence and human rights violations. But those laws on themselves don't exercise themselves. You need people in positions of authority and power and at the grassroots level to put pressure on those people in authority, to make sure that those laws are credible, that those perpetrators, frontline perpetrators who may be in a position to violate the law, actually believe that there is some likelihood that they could be held accountable. And unless would-be perpetrators believe there's actually a threat of punishment, then there's no need for them to really respect the law.
Right. Now, there is another issue here, which is it's a thin line, because we're talking about a force which is, on the civilian side, the coercive apparatus for any state. So it has to both serve and enforce. And so serving and enforcement become two sides of the same coin. Now, for instance, when we talk about torture, physical, emotional, mental, in a precinct, that's one thing. But then there is another issue of use of force. When, for instance, in terms of riot policing, to what extent can you use force? How do you define proportionality? Especially if the police can also make a case that the protesters or the rioters were extremely rowdy and were resorting to actions that could have caused physical injury to the police trying to, barricade or blockade their way from point A to point B. So in the heat of the moment, frankly, because we're discussing here, I'm sitting in an air-conditioned room, we're talking about this, which is important. But for someone, and this is more like I'm trying to be the devil's advocate here.
Yeah.
Someone who's on the ground, he or she can turn around and say, well, you guys are armchair analysts. We're the practitioners. We have to face these things. What would you say to that?
Well, I would say that there are a lot of things that are important. So we've been talking about kind of the law and regulations, and those are important for empowering people on the ground who do want to hold state agents accountable. But like I said, those laws don't enforce themselves. And so, it's important that you also advocate for not just legal and regulatory change, but also strengthening institutions and exercising those institutions that can enforce the law and, oversee and hold those who violate the law accountable. Courts and judges, play a major role in enforcing regulations and laws. So you need laws on the books, for example, that give judges independence from the government and the police, so they don't feel intimidated. or that can't be retaliated against in ruling against the police or the government. But even if you have those laws on the books, then you still need the willingness on behalf of judges to rule against the government. And there's a lot of factors that go into willingness. Perhaps judges are biased against criminal defendants who may be disproportionately poor, and they don't believe them if they accuse police of torturing them. Or maybe judges are so overworked and underpaid, they don't have the time or motivation to look more deeply into allegations, and they just dismiss them out of hand. Or maybe they're actually even taking bribes from prosecutors or others who have an interest in cases. So there's a whole lot of factors that go into the willingness of judicial and political authorities to hold perpetrators accountable. And so there's a major role to be played by activists, civil society, opposition politicians, and other political actors to try to pressure those types of state officials, judicial officials, to be more willing to use their authority to enforce the law.
Right. Just for the viewers, what Mark is saying is he explains it in his paper. He talks about why it's important to study criminalization. He looks at a global data set on criminal laws against torture to assess whether criminalization reduces torture by police. On that note, Mark, and before we end the session, I mean, there's so much one can discuss, but the global data set that you present in your paper for our viewers, tell us, are there those common strands that run through, or the data set presents those common strands for you to stress the fact that it's important to criminalize torture?
Yeah, so I'll just emphasize that, just like any scientific study, this study is not definitive proof. The data that it's based on are not perfect by any means. They're the kind of the best we can do.
No data.
Right, yeah, exactly. So you've collected
but you still
data.
have to, for quantitative analysis, which you're doing, obviously you need a data set.
Right, exactly. So you've been in this situation as well. These data are not perfect, but this is the best we can do, and so we do with what we can. And my analysis of the data that I do have does suggest that criminalization does have a modest effect on helping to reduce police torture, though certainly not eliminate it. It's definitely not a magic solution. But I think one of the interesting patterns you see in this data set, and the data set on torture I did not collect myself, it's collected by a group of researchers. I collected the data on the actual laws. But one of the interesting things we see in the data is that, going back to the point we made earlier about how there's different kind of modes or scenarios of torture. Sometimes torture is authorized by government officials as a policy or directed, and other times it's kind of carry out on behalf of individual frontline agents like police or security officials. One of the interesting things we see in this data set, to the extent that we can see it as valid, the data, is that even though we in the news, for example, we often hear most about these kind of high profile types of torture, these kind of politically motivated forms of torture, like the US torture program, for example, or torture in countries like China or Egypt, where it's seen as kind of very politically motivated and directed by high-level government officials. The majority of incidences of torture on a daily basis are actually committed by, say, police officers or other frontline agents on their own initiative. And unlike, say, politically motivated torture, which happens less often in democratic countries, the U.S. torture program being a kind of high-profile exception to that. But even though political torture is less often occurring in democracies. The other kind of torture of, like, police taking it upon themselves to torture, that happens in all types of countries,
Yes.
regularly. So that is the more common type of torture, but it actually gets less attention. And it's
Right.
actually, like I suggest in my paper, there's more you can do about that kind of
Yes.
torture in terms of
Yes.
using the law and other kinds of institutions, because the political leaders aren't as invested in that kind of torture, and they're not as threatened by efforts to hold perpetrators accountable for it.
No, no, absolutely. I think the essence of this discussion, frankly, is that there are levels, and since we are talking about criminalizing torture, in the event that there are political decisions or executive decisions or a policy to use enhanced interrogation techniques. That was the US case. You mentioned other countries also. I mentioned India, for instance, in areas where there are certain black laws that allow the police to, I mean, habeas corpus being one of the important things, and yet the police can keep someone for 90 days without anyone knowing where that person is. And that obviously violates the basic fundamental rights of that person against illegal detentions. So that clearly, when that is the case in those areas, expecting those states to actually criminalize torture would be asking for the moon, frankly. Then, of course, there are the issues of individual frontline agents doing this. But there again, it seems to me, because I have also been studying the police in Pakistan for the last 7, 8 years, that while individuals are responsible, lack of accountability and a certain culture of impunity, which is more broad, also contributes to police excesses and torture. But thank you so much, Mark. It was great having this discussion with you. And I must warn you that we shall draw on your expertise further down the road also. But have a great day, and we'll have other opportunities to further discuss these issues. Thank you so much.
Well, thank you very much for having me. It's been my pleasure
Yeah,
and my honor, and good luck with your work going forward. And I'm happy to talk with you again and anytime in the future.
absolutely. That'll be great. Thank you.